Good afternoon, everyone, and thank you for joining us today for our sixth of seven Cyber Phenomena Roundtables for 2025. Today's subject is data sovereignty, the implications of business operations and business continuity. I'm Mike Sheehan. I'm a board member of ISC2, and I organize this roundtable series along with the managing director of Phenomenati, Scott Foote. Today, we have another amazing panel, all who work for Phenomenati team, which includes Joel Jacobs, Steve Foote, Scott Foote, and today's facilitator, Mark Dunning. Mark served as the global head of IT for LEK Consulting, digital leader transformation in building a global IT team across a dozen countries. He drove enterprise systems, data, and security, achieving ISO 27001 and Cyber Essentials certification. Mark also founded the Decibels Foundation and Usher Syndrome Coalition, reflecting his blend of IT leadership and social impact. Joel Jacobs is a nationally recognized CIO and CSO with 40 years of IT and cybersecurity leadership. At Phenomenati, he leads virtual CIO strategy and advisory services, a CIO Hall of Fame inductee, two-time Boston CIO of the Year, and Federal 100 Award winner. Joel also serves on the board of the Advanced Cybersecurity Center and was formerly MITRE's CIO and CSO. Steve Foote is a software engineering executive and virtual CTO with expertise across finance, healthcare, intelligence, and law enforcement. He leads secure, agile software factory development using DevSecOps, cloud, and AI. A former Oracle engineer and co-founder of the distributed systems company, Steve holds patents, has authored over 1,000 publications, and serves as an expert witness and a board member. Scott Foote is the managing director of Phenomenati, serving as CISO, Data Protection Officer, Chief Information Risk Officer, and Chief AI Officer. With 35 years in cybersecurity leadership, he has led teams from 10 to 1,000 and driven major digital transformations. Scott authored The Risk Formula and Cyber Entropy, and frequently advises boards, nonprofits, and executives on risk and security strategy. We have a lot of material to cover today and a lot of people on the call today. So if you have any questions, you can put them in chat. And if we don't get to them, we can follow up with you. So with all that being said, please join me in welcoming today's briefing facilitator, Mark Dunning. Take it away, Mark.
Thanks, Mike. As Mike has said, I'm a vice president here at Phenomenati, and I'm fortunate to be joined by my partners in Steve, Scott, and Joel. As the four of us put this webinar together, we regularly described it as stuffing an elephant in a thimble. This is a massive challenge for companies in international environments with real-world implications, both for the business and for the individuals working in that business. So we're not going to get to everything today. So please, if you feel free to reach out to me with any questions you have. I can be reached at mark@phenomenati.com. It's MARK@phenomenati.com. And when we talk about data sovereignty, what we're talking about is really whose rules your data has to follow. Data sovereignty means that information is governed by the laws of the country in which it sits. So if your company stores data in Germany, it has to follow German and EU laws. If the data sits in Australia, it has to follow Australian laws. And this matters because as companies move data across borders, whether through cloud providers, global teams, vendors, or by using AI, they often run into conflicting rules about privacy, access, and security. And that's why data sovereignty has become such a hot topic. It's not just about where your data lives, it's about who controls it and what that means for compliance and business strategy. So Scott, let me start with you. How did we get to a place where both data sovereignty and severability are of such paramount importance for companies operating in an international environment?
Thanks, Mark. So let's go on a brief journey. I'm going to try not to bore people to tears, but you talked about privacy being a big driver. Data sovereignty was first and foremost about privacy, but in recent years, it's becoming about more than just privacy. It's other types of data that a country can claim some sovereignty over. And the more we see the tension in the socio-political landscape, tensions all around the world, and we'll touch on these, the more we're beginning to realize that this movement of data across a border is more than just the movement of data. It's business across borders, it's the information exchange that moves across borders, it's the risk that's introduced to the stakeholders of the information. And we're seeing sovereignty that exists everywhere else in, in physical land masses, whether it's road systems, in our maritime space with what's international waters versus national waters, in our airspace. We're seeing it in cyberspace. It's finally coming to fruition that countries are trying to draw borders in cyberspace. So we're going to talk more about how we got there, but let's start with just a quick walk around the world in terms of the need. And what does that look like? You've already talked about it, Mark, with data sovereignty. This piece alone is huge. Now, let me caveat what we're going to talk about in the first third of our session here by saying none of us are lawyers. This is not legal advice. You should definitely engage general counsel. And if you're general counsel, you should be looking at outside privacy counsel as well to interpret what are the legal obligations for your organization as you do business around the world in all of your operating environments. But in the upper right, it starts first and foremost, the sovereignty obligation starts with where the data is collected. GDPR is the perfect example. Many people say GDPR protects the rights of European citizens. That's not wrong, but it's not an accurate representation. GDPR protects the rights of anyone who is physically resident in the European Union, citizen or not. If you're resident in the EU, when data is collected about you, that is in scope for GDPR. You're going to see most of the other data privacy laws from around the world, and there are many. Most of them follow that same premise. So we start there, and then we flow through what Mark's already touched on. Where is it stored? Where is it processed and used? And then where is it transferred to? And do you have the legal right to move it across those boundaries? It is possible to establish the legal basis, but it's complex. And ultimately, what happens if war breaks out in one of these regions? We've got a lot of tension going on all over the world, but what happens if you have to drop a dome? You in your organization have to drop a dome on a city or even a country where you operate. You want them to continue to operate independently, but you need to have severability between them and the organization. So let's just walk around those countries on the left-hand side. This is just a cursory view that general counsel is going to make you aware of if you engage in this topic. These are the laws just in North America between Canada and the US alone. It's a patchwork, heavily fragmented. Some of it is pure cyber, much of it is privacy focused. So it's bound to that idea that the data that's of concern here is sensitive about a human, and it's identifiable with respect to a human. Same is true down in South America. There's some of them go back to 2010 and even before, but they continue to make the exact same progress that we're making across North America. We've already said the daddy rabbit in this space is the European Union. They had independent laws throughout the countries, and they've unified on GDPR in the last 5, 6, 7 years. And the UK has their own version of it, but it reads very much like the EU's GDPR. We refer to that a lot as kind of the high bar, and many of the terms that we use in the privacy space. I'm a certified privacy person, a variety of certifications, but many of the terminology that we choose to use, regardless of the region, hails from GDPR. In the Middle East or the GCC, the Gulf Collaborative Council, that's 6 countries. They've all come out aggressively in recent years, and they do not stop at just purely personal data, privacy data. The African Union, I don't know, most people talk about Africa as though it's a country. I'm disappointed when I hear that because of the number of countries that are there, but also the patchwork across Africa with respect to privacy. And some of these things hail back more than 15 years. So it isn't as though they're just starting and playing catch up. They are looking at whether or not it's possible for the entire region, like the EU, to establish one uniform approach. In Asia, for example, I scroll backwards. In Asia, we're talking about India is the biggest one there, and it's arguably got one of the more mature privacy laws, but so does Singapore. All of these environments are beginning to raise the bar in terms of the enforcement. GDPR led the pack, but all of these countries and regions are beginning to raise the bar. When you get into the Far East, it's no longer just civil. In China, violations of their data privacy laws are actually treated as though they're criminal events. So this is very serious, not just for the organization, but the individuals found to be at fault if they're ignoring it. And of course, not to be ignored, Oceania. Australia and New Zealand have had some laws that go way back and they've been continuing to modify, but so do a lot of the Pacific Islands. So the point in this walk around the planet was to say, this isn't an exception. It's not only in Europe. This is something that all of our organizations have to deal with. This is a global economy. Our users are scattered about the globe. Even our visitors to our websites come from everywhere. Well, if they're coming at you from somewhere in Tonga, you need to accept the fact that you have some obligation to adhere to the Privacy and Data Protection Act. It's in draft right now, but that act in Tonga. All of it comes down to sovereign borders. They actually matter, and they do exist in cyberspace. I've worked for NATO. I do not currently support them, but I contracted to NATO for 3 or 4 years at one point, and I had a few people there tell me that there was one internet. And I remember shaking my head, pointing at the 28, 29, 30 countries all participating and pointing out that every one of them had a cyber command that was participating in our exercises, whose sole job was to protect their sovereign portion of cyberspace. Now, what happens if they wind up at war? How do they maybe sever the whole country? How do they protect beyond just consumers? So this is a challenging set of obligations. The need is very real, but a small fraction of the world's organizations, whether it's commercial or not, only a small fraction have begun to embrace it. It's a moving target, but it's also hard to solve. That was probably way more of an answer, Mark, than you were looking for. But I wanted to establish that by simply saying this isn't theory, it's already happening. And every one of us on this call already have obligations within the scope of some of the things we've just put on the screen.
No, I think that was very helpful. And as we said, this is stuffing an elephant in the thimble. Just even looking at the breadth of the different acts that you need to be aware of and the different privacy and laws that exist. And this is just the beginning, really. I mean, Scott gave us the obligation landscape, but there's other real risks associated with this beyond for companies and individuals beyond a fine for noncompliance, right?
Yeah. So Scott touched just ever so briefly. Again, not an attorney, but I'll point out the majority of the laws tend to be tortuous, meaning they're civil infractions or offenses. There are a number of countries, and Thomas Hart, I'm going to play on your point here in the Q&A, that treat some of these transgressions, data sovereignty transgressions, as criminal acts. Thomas puts in here that China regs are a contradiction for the rest of the world. And Scott, feel free to jump in if you want to embellish, but I'm going to give a China example because Tom's just fired those neurons for me. Spring of 2023, dating back maybe 6 months prior to that as well, Chinese government actually raided Bain and Company in China, raided their offices, took equipment, examined data, whatnot, because of concerns of violations of the national security laws, as far as just sharing information amongst the clientele that Bain has. Second one, not alone for Bain, second one, Mintz, M-I-N-T-Z, also had offices raided, whatnot. As I recall, if I have the names correct, this is the same time period, this is early 2023, Mintz had 6 staff detained. So that was a little bit further than Bain. And then lastly, CapVision, don't think Capgemini. A lot of our American and European audience might jump to Capgemini, not Capgemini, CapVision. CapVision was a spinoff of Bain and McKinsey partners some time ago there in China. So this is not a US or European entity. This is a Chinese-born entity, CapVision. They actually have one of their staff who was sentenced to 6 years for violating national security laws. Why am I bringing this example up? Thomas makes that good point. China takes it seriously. And to Scott's point, this isn't just about individuals' privacy. This is about the inherent private nature, in this case, that fits inside the definition of what is restricted from a data sovereignty perspective. So there's one example of a country that's taking their laws very, very seriously in the way of defense. Let me give you another one, though, on the offensive side, and that is we've all read about the North Korean operatives posing as remote IT staff. I'm going to even argue that they're not posing. They're actually doing remote IT services, but they're exfilling. One, their paycheck goes back to North Korea. Two, anything that they can collect, the value, gets brought back to North Korea. Who do you think is liable if your company happens to hire a North Korean operative and your customer's data winds up exfilled and sold out on the black market? You're liable. Your company is going to be, brought to bear underneath the various, territories that Scott's laid out there. It could be actually quite expensive. So real quick, before we begin to segue, we got 2 more open questions. I'll answer the AI related question more deeply in just a little bit. Do we see organizations deciding not to do business in certain geographies because of data rules? And a point, remember, all Chinese citizens are required to provide information to the Chinese government. Yeah. So, Mark, I don't know, that might be a good segue. Do we see organizations deciding not to do business in certain geographies? Might be a good segue over to Joel.
Yeah. So, Joel, we did a webinar back in the spring about on the threat landscape. And for those of you who are watching, you can find that webinar on our website, Phenomenati.com, if you're interested. But can you give us some real world examples of how these socio-political conflicts directly relate to data sovereignty?
Yes, there's a few things. One is upticks in cyber threat activity have followed physical conflicts pretty tightly, and sometimes even led ahead of physical conflicts. If there's a place in the world where there are tensions rising, there's also very likely to be an increase in cyber attacks and threat actors focusing and trying to take, even cyber criminals trying to work in the background in the turmoil that's caused associated with some real world hostility breaking into violence. On the point about organizations deciding not to do business in a certain area, we see people considering it more than they used to, and that's a recurring thing in among our clients, where organizations want to enter into a new region or a new individual country and are much more planful and thoughtful about what the effect of that might be, because the arrangements around pervasive access to data from anywhere to anywhere is harder to count on, and frankly not an important, not a credible thing to count on anymore, because the boundaries are increasingly real. So if your arrangements with one of the large cloud vendors may change significantly if you need to ensure the data sovereignty of the data that you're involved in or your customers are involved in. And that is increasingly true. And deciding not to do business after the fact can be very expensive. We do see companies that have had a presence in a location and now are kind of regretting it and would like to find a way to work back out of it. The most extreme example is a colleague of mine who was a CIO at the time of the outbreak between Ukraine and Russia had a software development team in Ukraine who reported to a software development team in Russia at the outbreak of the war. And that was a pretty radical change in their operation, including the content of the data that was their intellectual property for their product lines that were now split across these two warring countries, and one of which was heavily sanctioned. So there's an effect of actual kinetic warfare that worked all the way back to the architectural choices and the organizational choices of companies and where they do business.
So yeah, that's great, Joel. Thank you for that. And yeah, we have seen clients who are, it used to be solely thinking about the market there. Now they think about the market and they think about the impacts of the data sovereignty laws, and can they establish a foothold there that will be successful even within the boundaries of those data sovereignty laws.
One last comment on that,
Yeah.
Mark. There's a cost to those choices. There's a cost to the controls that are needed for where you happen to have your data and where you're responsible for its protection. And that has to be factored into the business choices.
Well, that's a great segue into this next section here. We wanted to talk about, we've sort of terrified the audience at this point, so let's try and give them some hope. Scott, if you could bring up that architecture diagram, that would be helpful. Can you go to the one with the boxes first?
Yep, I wanted to jump to that, but the first thing I wanted to do is just talk about
Yep.
every program. Certainly everyone that we deal with in information security and privacy, they all have these components: administrative, technical, and physical. And the physical controls become very real. In spite of people thinking the internet is one contiguous, right, ungated physical entity, it is not. So let's jump to the architecture slide. This is usually when we first engage with someone, we talk about what's in your portfolio of controls already that isn't all just technical. Everyone thinks it's going to be a technical control. On this particular challenge area, we have a lot of administrative and physical.
Yeah. Yep.
But
that's good.
That's the slide you were talking about.
Yeah. So this is what I was talking about. And as you guys can see from looking at this slide, and feel free to take a screen capture of this. You see, data sovereignty is just one of the things in here, and there's a lot more that you need to consider when you're considering data sovereignty. That's why, if you think back to one of the earlier slides, you may have seen that Scott had crossed out data sovereignty and put in cyber sovereignty, because these days you really need a cyber sovereignty architecture. Data classification and labeling is just not enough. You need to consider the architecture that houses and allows access to the data. You need to consider the applications that manipulate that data. And you need to consider governance policies and governance and policies that determine the proper use of that data. And then on top of that, you also have to prove that you're following the rules that have been laid out. So you need observability and response. And that not only needs to meet the regulatory reporting requirements, but it also has to operate within the data sovereignty laws of that jurisdiction as well. Now, there's a ton here to go through. So I know this is going to be a little bit too much for us to touch on for everybody. Again, feel free to reach out to me at any point if you have more questions. But Scott, let's just start at least with the compute and network sovereignty that an organization should consider, and where the data is and how it is accessed.
And actually, Dave's got a really good question, Scott, and Joel, if you could weave it into the narrative. Should insider threat be listed here, specifically given Steve's North Korean example, or is that just table stakes? So if you could work that in, please, that'd be great. Insider threat.
Yep. Well, I don't know if you want to jump on this now, Joel, but we spent a lot of time looking at the insider threat problem for our larger clients. And let's say it's a risk scenario. Was it Dave that asked the question?
Dave.
Yeah.
David. Sorry, it's David.
David, it's absolutely a risk scenario that needs to be considered, because more often than not, the insider, whether they are somebody who is already resident in the country where you have ops, and they've simply, turned negative on you. They've soured whatever it is they've been turned, or whether it's somebody who truly is somewhere else, just masquerading, pretending to be in your sovereign country of operation. They almost always move the data across borders deliberately, because it's harder to basically enforce the laws, to talk about who is responsible, who moves the data. And most criminal networks, they split up all the responsibilities. There's a diffusion, so no one is responsible for the crime writ large. Many insiders, while they will steal the data, they don't do the cross-border transfer. It gets handed to somebody else. That person may strip it down, box it up, encrypt it, chunk it, whatever, and they may be the ones that move it across borders. But absolutely, the insider threat takes advantage of the fact that there's been very little enforcement with these cross-border thefts. And it's hard to take one individual and say anything more than you were responsible for the original theft. Excuse me, theft. Joel, do you have thoughts on that before I
Y-
jump into our
Yeah,
commentary?
I'll just add. I think insider threat is a really difficult topic to get focus on because it's creepy, and the responses to controlling the insider threats or detecting insider threats are inherently uncomfortable. This is something actually that we've been using as a pretty regular topic for executive tabletops, is dealing with insider threat and dealing with insider threat across geographies, and the complexity of that, and complexity of the observability in that. And to Thomas's point, it's asymmetric. The threat actor, especially an insider, doesn't have to get it right all the time, but those who are defending and detecting do. And so there's an asymmetric element to that.
So let's jump back to Mark's question, which is how do we peel this onion? This is a very complex problem. So how might somebody start to peel the onion? We use architecture, graphics like this to basically decompose the problem into things that are more discreetly addressable. And it's yes, it looks like the OSI stack for those of us that are familiar with that, probably most on the call. But we start at the bottom with what is actually physical. Where are your physical compute infrastructure resources, hosted or on-prem? Where are those things and how are they networked? Because no matter what my friend at NATO said to me at one point, networks are not abstract, they are concrete. They are actually implemented in some way. We build abstractions on top of the physical media, but they are absolutely physical, even if the physicality is electromagnetic waveforms and frequencies. So, in other environments, some of us here have done a lot of work in government spaces. I mentioned my NATO work. The rest of us have done a lot of work with the US government. And even today, there's a lot of air gap in that space. So at the very lowest level, we need to look at what might need to be isolated, what physical perimeters might need to exist. We build on that with that network sovereignty layer, where now instead of just doing the basics of things like 10 years ago it was MPLS, and before that it was frame relay. Instead of just looking at that, we're looking at software-defined wide area networks. A topic that I get into a lot with our customers is SASE, and inclusive of SSE, the security service edge within the broader SASE, is how do people set up a wide area network, a corporate network that spans all these geographies, but does so in a completely limitless way and enforces controls not at the firewall, not purely at the firewall within the physical office, but all the way up and around all of our business systems. Above that, compute and storage. 99% of us are outsourcing that to the big players, whether it's a colo like an Equinix environment, or whether it's one of the more traditional brand names like Google, Microsoft with Azure, AWS, or some of the smaller players. We're outsourcing it because it's cost effective. What exists in their spaces to give us clusters that are strictly regionally scoped, not just convenient, but actually are adhering to the sovereign laws of the countries where we need to operate? Why am I picking Frankfurt over the Dallas in the US. Why would I do that? Maybe because I'm housing data that is bound to the sovereignty of the European Union. So in that stack, there's more available to us than there ever has been. We're not seeing the mass market do adoption of these lower levels yet. They're still doing the basics of, I'm going to outsource to AWS. I don't really know where they're going to put it. Maybe I'll get high availability and I'll put it in 2 zones. But most of the folks we meet for the first time have not yet gotten to the point where general counsel comes in and says, you can't put that data there. Even if it's a backup for high availability, we don't have the legal basis to be moving that data to that area. So that's the lower level of the stack. Why don't I open it up to some of the rest of us? Or Mark, I think you have another question that takes us further up the stack here.
Yeah, I think the view that we have in the IT side have traditionally taken about this stuff is that the physical part is the location is the only thing that matters from a data sovereignty perspective. But as you're pointing out, Scott, I mean, these days when you put stuff into the cloud, where is it? Where does it live, and what laws does it do apply to it these days? And Stephen, that's just, kind of the physical layer and the hardware layer. There's also, that's really not what the user experiences. They use AI, they have identity management that they interact with, there's applications. In some cases, there's cryptography used to access this data. What does that part of the architecture look like in international organizations?
So as we slide into that, Hans has got a question, which I think we can weave in here. How do you guys see digital supply chains managing compliance across these borders? Could AI and automation play a big role here? So yeah, let's get to that one in about 5 minutes. And then Thomas points out or questions, small and medium orgs cannot afford the legal teams, so they can take their changes.
Chances, I think, is what
chances, right? Yeah, I think you're spot on there. Yeah. So let's try and touch upon both of those. Scott, could you give me one click here? I'm going to begin to answer Hans' question here by coalescing the noise that's in all of the architecture, and that is that there are a number of vendors, Microsoft, IBM, AWS, Google, that are now offering the concept of a sovereign cloud. And that is that you've got the lower side of this architecture, the more physical compute assets, all the way down to the actual drives that are strictly located in a given domain, guaranteed to be located in a given domain. So for the small and the medium orgs, for due diligence and due care, Thomas, is we're going to land on that one towards the end. We certainly hope to anyway. They should start to consider not quite shrunk wrap solutions, but at least look at the concept of the digital cloud. I will put the stake in the ground. This is not my grandmother's client server architecture footprint anymore. That is not going to fly if you are an international company. And one needs to be considerate of the server in the server based upon the geography of the client, if you will. So I'm using very dated architectural footprint, but give me one more click, Scott. What's really intrinsic is to rethink the concept of the user. I'm going to say customer, but consider user, because this comes back to the earlier question of David's also about insider threat. Consider now that Steve might have, I'll use a commercial example, not one, but 3, pick the number, 3 sovereign identities, 3 synthetic, but identities that are located in a given, have a residency is the right term, in a given geography. Maybe I purchased through Amazon in Korea. Maybe I purchased through Amazon in the US, and maybe I purchased through Amazon in the EU, in Germany. Okay, well, there are laws that are different that apply to the usage of my transaction information in those 3 different geographies. So the assertion here is that you don't have one identity, you actually have 3 sovereign identities. And you could imagine from the end user experience, if I go to my settings or if I go to my orders, I'm actually going to see them binned according to the sovereign locations or the sovereign identities. If I choose to say in the US, I have a right to be forgotten, great. Okay, the middle one's gone, but that doesn't apply in the EU and in Korea, different laws. Now, why do I say that this is intrinsic to all the way back to David's point about insider threat? Well, one of the things that companies are beginning to do is to apply cryptography associated with the identity around the digital dust that that identity leaves. And that cryptographic footprint should be in the sovereign cloud below the sovereign identity. So to my example, at Amazon, 3 different sovereign identities, all under the same login, but 3 different sovereign identities, there would be 3 different public-private key pairs that are associated with my digital dust that I'm leaving in Amazon in those 3 different sovereign clouds. Dare I say, that could even be a customer managed key where yours truly says, not just I have the right to be forgotten in the US, yea, verily, I am going to revoke and or destroy the key associated with the sovereign identity in the sovereign cloud associated with the US. This is not science fiction. We're not making this up. This is sort of rudimentary for doing business in the 2025 and beyond with regard to all of the divergent laws, regulations, compliances that one has to deal with an international footprint. Scott and Joel, did you want to dive in on that? That was a long soliloquy for me. So
I just want to throw one. I'll be short. I promise, Joel. One comment here is the fact that the entry point here is attribute-based access control. We all talk about RBAC all the time, role-based. But Stephen, you're talking about attribute-based. It's not just enough for me to have a role. Some of those roles may be heavily redacted or expanded based upon an attribute that is, say, a geotag of the identity of my identity, not just the data that I wish to go work with and access, but my identity and where I'm currently sitting. So ABAC is becoming a much more important consideration now in these more complex models.
So that's very helpful. Thank you, Steve and Scott. As this is, we've been talking mostly about the technology here, but there's more to this than just the technology. I mean, there is there's still a human element associated with this that decides who can access that data, and then there is the need to prove how that data has been accessed. So Joel, how does that happen, and how does that figure into this architecture?
I think it's less well formed than the component technologies. As companies wrestle with the idea of having the necessary governance to have the data that's supposed to be in one place stay in that one place and still be useful to the enterprise. And the regulations are really about physical location of the data. It's not as clear about whether you could have a shared space where some portion of that space is dedicated to service a different location or an individual location, but no others. So I think this will play out in different forms because the ability to do business in a given region is going to be affected by the local region, and there may not be a presence for the products that you want to use or those software as a service platforms that you want to use to execute. So the idea of getting the governance necessary within a given company and then marry that up with the offerings across different spaces in different locations is going to be an inherent challenge. But it needs to be done. And anybody who's dealt with data loss protection, data loss prevention, or data labeling, these are nightmarish projects, and the vast majority of them fail because of the complexity of getting the alignment of data ownership and the necessary controls. I hate to be negative about it, but it's important, but it's really, really hard. The ability to make the appropriate decisions about where things can go, what services it can be part of, where data can reside or needs to reside, still needs to be worked out. And it's a complex topic that is at least as much legal as it is technological. The observability part and the monitoring and response to changes or violation, there's places where technology can help identify the issues, enable the effective architecture to make it work. But it really needs to have the rules set, and the rules need to be set between cybersecurity, IT, and legal in a company.
Joe, can I build
Right.
on that real quick too? Because this comes back to one of the first questions that was posed, and that is, if in this utopian world of sovereign identities and digital dust is encrypted with a key that's associated with each identity, even if the digital dust is exfiltrated by an insider, potentially, out of its residency in a sovereign cloud, the usage of the keys provides a good measure, but almost an audit log of who's using the keys to decrypt and where does the decryption actually occur. So yeah, that's where one could insert the use of AI, because the use of the digital key itself is to decrypt. That log entry is probably not going to fall underneath any data sovereignty laws. So one could accrete the log entries, use AI to do pattern matching, and recognize when you have anomalous behavior of digital dust, yours truly as the customer, getting decrypted outside of its residency, and is that in fact anomalous behavior? Yes, there's certainly the opportunity to apply AI to facilitate this against the derivative information, the log information of what's been decrypted. So just wanted to put that out there.
And I agree that using crypto sovereignty, crypto segmentation of the data and the service and the communications paths ought to be as acceptable as the physical separation if it's done well. But I don't think they're there yet in the way the regulations are written, and it's not surprising that they could lag as laws get passed and enforced. It's a more complex thing to accept.
All right, so
I had one more thing I wanted to add to that, which answers one of the earlier questions, Mark, about what about supply chains? I mean, we're talking about this as though this whole stack is in complete control of one organization, but I don't remember who it was, Stephen, that brought the question up. Maybe it was David. So we see this all the time today, and what we have there is an administrative control. Other than whether or not we are sharing things that are cryptographically protected, where we can grant someone use of a key and then revoke the key to crypto shred it, we really are left with just administrative controls. And today, that is essentially the data protection agreement, at least with respect to privacy data. We have the data protection agreement, which says, I'm going to hand the data over to a SaaS provider who will then hand it over to, say, Google, GCP, or something like that. And the data protection agreements need to be explicit. Exactly what data are you sharing between these parties? What do you expect it to happen to it? Why? And what's the legal basis? But where's it going? Is it going out of country? And the entire supply chain today needs to be documented by DPAs. And in my CISO role, unfortunately, that takes up an inordinate amount of time when you're looking at third-party risk management, vendor risk assessments, is not just what is the first DPA with first order vendor, but cascading all the way down. Who do they have as sub-processors, and do you have the administrative control in place? It is not by any means perfect. Crypto around any of these sensitive pieces of information helps tremendously. But the fact that none of us exists in this silo all to ourselves, we rely on a supply chain, makes this problem even that much more complex. But I cut you off, Mark. Let me throw it back to
No,
you.
no, that's good. That actually leads right into my last question here. You know, our audience is feeling pretty overwhelmed by all of this stuff. In fact, it seems like we've driven
Thomas
Thomas
suggests
into
Yeah,
it's time
Thomas
to
is
retire.
retiring. Yeah.
Yeah,
we drove
brilliant.
Thomas into retirement, which is exactly the goal of this webinar. You know, Joel talked about these labeling projects failing. Scott's talking about you know, the concerns around the supply chain. Stephen, is there a way to just have some product out there do all of this for us? I mean, is there somebody that can just do this for companies?
The easy button.
Yeah,
Yeah,
that's what we need.
yeah. Take us to the next slide. Ow, that hurts, Mark. Oh, what did you use? Legal font? Is that 1-point font or is it 0.5-point font? Yeah, Mark, the answer is, as Joel has intimated, there isn't a one-stop shop. The big players, I threw the names out earlier, Microsoft, IBM, I didn't mention Oracle, they're a player in this space, obviously. They have solutions that are increasing in scope and richness with regard to the robustness of the features that they offer. And yeah, actually to Thomas's last point there, what about encryption in memory? There is some crypto out there, not in these tools, but there is some cryptographic techniques out there which allow you to retain the cryptographic footprint of the data while it's live in memory. However, in this particular case, there's a bit of a shock value as Scott scrolls around the density of this. The key point here is due diligence. The answer is not 0. The answer is not yes to Mark's question. There's an easy button. It's in the middle of that. And it's a rapidly evolving market because it's a very high value market. International commerce is high value, notwithstanding the US tariffs that we have in our present day. The situation is that one needs to perform the due diligence and begin to make deliberate decisions on what a company can afford, both technically, economically, but strategically. So there's an implied roadmap, if you will. And in applying that due diligence, you now establish the due care standard such that when you do, and it will happen, you will get into a forbearance, you'll get into a litigation situation, civil or criminal. You need to establish that you have applied at least the baseline of due diligence to understand the nature of data sovereignty. And then from that, from a matrix like this, you begin to apply the technologies and demonstrate the due care associated with your fiduciary responsibility to data sovereignty.
So looking at this list that you have here as well, that we put together here, just 3 years ago, there was almost nobody out there operating in all this. With all of this, these new regulations that are coming out from so many different countries, it is really driving a market for these things to exist. So there will be more and more of this coming. But to Steve's point, there's never going to be a single one-stop shop for all of this. So guys, are there any other comments that you want to make?
I want to go back to the question that I think it was Thomas had about small and medium affording it. They can't afford to build it. They may be able to rent it in the right circumstances, the right presence of a provider who knows what they're doing in a given location and is able to demonstrate that they're following the rules, the laws appropriately. Trying to build it from scratch may be beyond the pale or beyond the capabilities of most companies.
But you also made a point earlier, Joel, that I would paraphrase it and say, this isn't just a technology problem.
Yeah.
This is an all of business
Yeah.
problem. You know, Stephen mentioned, get your general counsel involved today. If they're not already involved, they need to help you map out where your obligations in all of these regions. That was the point in wandering around the planet earlier. And
Yep.
you really have to understand the data itself and how is it used. We're
Yep.
not saying those laws prevent you from moving data across borders, but you do need a valid legal basis. And there are other rules that apply, such as data retention, minimums and maximums, the data rights of those subjects, and whether or not they can ask to be forgotten. Stephen touched on that. It's all a business problem.
Yeah.
It's not something that you can simply buy tech and feel like you're done.
Yeah, fair enough. I didn't mean to imply that, you know, call Microsoft or Google or somebody and you're done. But they can take a good portion of the technology burden off if they're well aligned to that particular location and that kind of data. And that is determined internally, not just by browsing a website about their products. Internal organization has to come to conclusion that it's effective for their purposes.
Hey, Scott, we got a question too here at the end, sharing/passing risk, ? If you'd like to point out, it's not always the technical adjudication of mitigating risk.
Yeah, so I'm one of the risk professionals amongst us, and people talk a lot about risk treatment. Can you accept it, reject it, mitigate it? And there's the fourth one that was just asked about. Can you transfer risk? And the fact is, you can never give risk away. You can't transfer it fully. You can share it, as was implied by the audience member asking the question. You absolutely can share it. That typically is expressed explicitly in things like your MSA, your master service agreement, and your DPA, the data protection agreement. You talk about who's on the hook for what level of protection and who has compensating controls on their side of the boundaries of the relationship. But absolutely, in the supply chain, everyone in that supply chain shares the risk at some level. Further down you get, of course, the lower the liability typically is, but everyone shares that risk. And having a risk professional that can sit down with you and talk about these administrative controls is another important aspect of figuring out how are you going to tackle data sovereignty, not just legally, but practically. How are you going to address the challenges in front of the business?
All right. Well, thank you guys. And thanks to everybody who joined today's conversation on data sovereignty. As you've seen, we've discussed today, data sovereignty isn't just a regulatory box to click. It has become an architectural imperative for companies operating internationally. And as you go back to your teams, I would encourage you to have start three conversations. One is, are you confident in where your data is stored and how it is moved across borders? The second is, do you have visibility into the regulations that apply to you and those that may be coming? And third, is there a way you can actually turn data sovereignty from a risk to an advantage that builds customer trust? And if you'd like help answering any of those questions, we at Phenomenati would love to help you with this. You can reach out to me at mark@phenomenati.com. Again, that's MARK@phenomenati.com, or simply check out our website at phenomenati.com. And thanks to everybody for joining today.
Okay, thank you, Mark, and thank you, Joel, Steve, and Scott. That was a great session. We did record the session for those of you who might want to share it with your teammates, or you want to dive into something a little deeper that you may want some reassurance on. We will get the recording out to you. For those of you who wish to get CPEs and didn't fill in the information when you registered, please get that information to me. And if you're interested in talking to any more about the panelists, as Mark said, please feel free to reach out to him or any member of the Phenomenati team. And certainly you can reach out to me and I can help broker an introduction if you'd like, as you all have my email address on the invitations. Our next roundtable is September 24th, Risk Level Agreements, Risk-Informed Decision-Making, at the same bat time, 12 p.m. And thank you for everybody for joining us. Enjoy the remaining of this beautiful New England day. And that concludes our briefing. Take care, everyone.
Thanks, Mike.
Thank you, everyone.
Stay safe.